Well, hey, really excited to moderate this discussion. I was actually joking with Harry a few weeks ago. We ran into each other at another event, and I mentioned to him that corporate practice of medicine was probably, as a California healthcare attorney, was probably the first doctrine I think that I learned, or at least tried to learn. It's probably sort of the area of law that I encounter the most these days. So it sort of comes full circle. As you all know, and as many of you know in the room, it's such an important topic for California healthcare businesses, individual practitioners, and lawyers. It informs deal structures, implicates individual clinician licenses. It's closely related to a lot of other similar regulatory issues like fee splitting and impairment of medical judgment. So really excited to talk with this group, especially because I think each of you brings a unique perspective and opinion on the topic. So with that, I don't know, maybe I think we can start with just a brief intro for each of you, regarding just your practice, and then also, your role and how you encounter this issue. And maybe just start with you, Jamie, actually, if possible. I'd love to sort of get a sense of the role of CMA in terms of general advocacy and education for physicians as it relates to an issue like this.
Yeah, absolutely. Jamie Ostroff, I think they ran out of ink. So I've seen healthcare law generally, and the corporate practice of medicine more specifically from a number of different angles. I spent a number of years as an attorney at Blue Shield, California, where I encountered it there initially. And then from Blue Shield, went to work at Hill Physicians Medical Group, which is a really large IPA in Northern California, where I served as general counsel. And so from the position of a large physician-led organization, and now as general counsel of CMA, it's one of many issues that I encounter on a regular basis. But again, it's the perspective from which I see it at CMA is a little bit different than how I saw it from the others. And then turning to the CMA's role generally, our advocacy and education at CMA is pretty extensive. Our legal team works closely with our government relations team on legislation. We advocate with health plans through what we call our Office of our Center of Economic Services, and with the regulators regarding payment disputes that providers may be having with payers. We draft comment letters. We work directly with regulators on proposed regs. Most recently, we're very much involved in the draft OCA regs, the Office of Healthcare Affordability. We're also very active in filing amicus briefs in matters that impact the practice of medicine. And those matters can be very broad. Relevant to this topic, in the Envision case, we did file an amicus brief in that matter, but we also filed briefs in cases involving public health, the No Surprises Act, First Amendment issues. There's a case right now involving, or called Palmer v. Bonta, which is a First Amendment challenge. In fact, things as mundane as standing under state and federal law. And then also, I hope many of you have heard of, we've published the California Physicians Legal Handbook, which is a treatise directed to physicians, but that I can say myself, when I was first joined Blue Shield, that was my go-to treatise first when I was faced with an issue, because it was a great place to start off my research.
Great, thanks, Jamie. Rick, maybe go to you.
Yeah. Let's see. How's my sound? Okay. Rick Reifenbach. I'm a partner with Shepherd Mullen. And the corporate practice of medicine doctrine has been a legal doctrine that I think has been my favorite doctrine during my entire time as a healthcare lawyer. And so it's been something I've tracked over the years in terms of case law, attorney general opinions. It tends to enter my world in transactions when we're structuring whether it's friendly PC structures or doing diligence on potential targets that have similar structures or employment arrangements that we need to vet. And so that tends to be how I work on it. Love working on management agreements, getting into the weeds on exceptions to CPOM, and just tracking the different types of developments that we're going to talk here about tonight.
Great, thank you.
And so Oh, sorry, use this mic.
Yeah,
I'm getting instructions to use this one. Is this one on?
take care.
There it is. So first, I just want to say, Harry Nelson, as the managing partner of Nelson Hardman, I want to thank LA County Bar Health Section for coming over here, and it's been really wonderful to see so many friends and colleagues and to be able to host tonight. But in terms of corporate practice medicine, my work, I started my career doing compliance work for in Chicago and really advising on in terms of structural compliance. And then came to California and started doing a lot of medical work and still straddling that line in between trying to advise clients prospectively how to be in compliance with it, but then getting pulled into a lot of situations where people are getting in trouble for allegedly not being in compliance with it or actively, flagrantly not being. Really conversation.
Thanks, everybody. Rick, I think just to lay the foundation here and maybe educate folks a bit who are less familiar with the specifics of the doctrine, could I turn it to you to maybe provide a high-level overview of some of the fundamental components of CPOM?
Absolutely. Let's get into it. So this is going to be a refresher for most of you, and it's going to be sort of CPOM 101 for those of you who are new. And I'm going to go through these slides pretty quickly because I have too many. And I think there's more fun stuff that's towards the end. But in a nutshell, corporate practice of medicine is generally defined as the operation of the medical practice by entities that are not themselves licensed to practice medicine. So you can't have non-physician owners or licensed practitioners who own medical practices. It's a general prohibition on lay entities employing licensed professionals, specifically physicians. The states have different varieties or flavors of the corporate practice doctrine, and so it's important to look at each state if you're working on a multi-state project. Some states don't have a corporate practice doctrine, others do have some form of corporate practice doctrine, although California tends to be the most robust or one of the handful that are robust. Okay, yeah, next slide here in terms of the limitations covers several of these. Engaging physicians to be independent contractors in California, where the entity that's engaging them is billing and collecting for the services. Direct medical purchases purchases of medical practices by PE entities, private equity here in California, also a no-no. And then anything that interferes with the clinical judgment of physicians from an unlicensed person or entity also is on the list here. And so you'll see this reflected in some of the cases we discuss and also AG, Attorney General opinions. When we talk about the corporate practice of medicine, we're typically talking about physicians, but I wanted to note here on this slide that also depending on the type of practitioner, it may have a similar limitation as well. So we've listed some of them here. So you might be working on a transaction in the physical therapist space where you need to take a look to see what are the rules in that state about who can employ a physical therapist. Okay, so
I'm happy to go back. It's too fast.
It's good. Let's keep going quickly here.
Keep a rhythm.
So the rationale for CPOM is really to protect the independent clinical judgment of a physician and other licensed professionals. I mean, that's in a nutshell. When you walk into a physician's practice and you're seen by that physician, you want to feel like they're not going to be influenced by the profit motive of a for-profit entity. And I recently presented on this at UCLA Law, gave them sort of a CPOM 101 presentation. It was interesting to go through these. I went into a little bit more detail about the policy behind it, and then turn to the students and ask them, what do you think? Are you persuaded by that or not? And most of them felt like there was a place for the CPOM doctrine still today. Even though, a number of states might be considering getting rid of it, or, you hear about that from time to time. Anyway, I sort of encouraged that they thought that there was some value in it. So, okay, we could go back one second. I didn't say, many states have a form of CPOM, and I listed the states here that I think have, particular, traps for the unwary that you need to do a close review of those state doctrines. And then also, it's a pretty standard, junior associate project at firms to do 50 state CPOM surveys. And so I've done a bunch of those in my day as well. All right, thanks. All right, I added this in for the UCLA students, but I also wanted to mention it here too. It's like, why do I think CPOM is so fun? I like it just, guys, there's a lot of history to CPOM, it's got interesting cases, like I put Painless Parker up here, which is one of the, foundational cases here. Each state is different, and so I feel, you understand the California laws, we go to a different state and the rules might be entirely different exceptions, or may not have a CPOM prohibition at all. Working on large national projects like a multi-state telehealth project, it requires you to look at these laws in different states, the licensing requirements in different states. And I just think it's interesting to come up with a strategy for clients about how do you stitch this together to come up with, something that's going to work for them. It's not intuitive. I mean, when you hear that doctors aren't employed by hospitals, that comes as a surprise to some people. And yet most hospitals cannot employ physicians in California. Interesting workarounds. I mean, we're going to talk a lot about the friendly PC structure, which has become, as many of you know, a very common and important structure here in California. But these, grappling with the doctrine and trying to come up with a way to accomplish your client's goals while complying with the law, I think makes this fun. And then it's always evolving. The reason why we've done multiple 50-state surveys is because the laws change. Medical board issues different guidance. There's new cases. I mean, Harry pointed out a case that I hadn't seen, that it came out just a few months ago, that involved a friendly PC structure, that it was, completely on point and really a fascinating read. So there's always stuff like that coming out. We're going to talk about a little bit of proposed legislation that didn't happen, but might have turned the friendly PC model on its head. Okay, I'm going to go through this very fast. But so the origin of the CPOM doctrine, and really where to look. So if you're going to be doing research into this area, where should you look to find out how to interpret a state CPOM doctrine? I've listed it out here. I've got some more detail on the subsequent slides. I want to put a plug in though. The reason I printed out the California Physicians Legal Handbook chapter on CPOM, because like Jamie, I think it's just an amazing resource. And it's one that I always turn to on this and really other issues as well. I just think it's very well done. And then also I want to give a shout out to for the AHLA CPOM treatise, which there may be others in the room who also worked on it. I think it's a fantastic resource and one that I use often, although like I said, you need to double check and make sure there's not anything more current. Okay, let's go through it. Okay, so you need to check state statutes. I'm not going to read this stuff, but this is Medical Practice Act statutes in here that are on point. Some states have an express CPOM prohibition, like California. Others don't, so you need to check the state statutes, Medical Practice Acts. I also recommend you check the state anti-kickback statute, which may have relevance to the CPOM prohibition as well. In California, on the next slide, as you probably know, there's an exception or a safe harbor in our anti-kickback statute that permits payments that are based on gross revenues, as long as they're not correlated to patient referrals. And that's an important safeguard, safe harbor that we use for the friendly PC model when it comes to management agreement structures. Next slide. Medical board guidance. If you haven't been on the California Medical Board's website, they have a CPOM FAQ that has a lot of good information about the sort of do's and don'ts. And you want to pay close attention to it because sometimes in management agreements, they'll be, I think, too expansive in terms of what they're allowed to do. You need to dial them back by, I think, referencing this medical board guidance. And also this recent case that I mentioned that Harry directed me to, I mean, they even quoted this medical board guidance right there in the opinion. So it tells you how important it is. And then attorney general opinions. Harry's going to talk about one of these cases in more detail. He's got a slide with some more information. But it's a great resource for these types of issues as well. California AG has issued a number of opinions about this. This is maybe half of the ones that are out there, but they're very informative. Some of them are very old, so I think you need to be careful about relying on things that are super old. But it's definitely a place you need to check when you're doing this type of work. And in court cases as well, the Epic medical management case is a fairly recent one that a lot of people look to and rely on for the friendly PC, well, for management company do's and don'ts. And then this Allstate one that's at the top is the new one I've been mentioning, which reviewed a friendly PC structure, and it had a lot of important guidance in there as well. But these are some of the key cases to consider. Okay, so the penalties for violating CPOM listed out here. I think a couple of board enforcement actions, medical board coming in. Barry and I were talking before this. It sounds like he's seeing a lot of medical board enforcement around these types of issues. I've worked on some of those cases where the medical board has come in and made us restructure arrangements, tighten things up in management agreements.
Would you say that that's sort of like the most common sort of enforcement action? One of the things that I struggle with, over the past 10 years, when I get clients always ask me, well, what is the risk? How do I quantify that risk? This seems pretty broad. So
yeah, it's a great question. I mean, I would say medical board is towards the top, if not at the top. And it can come up from competitors reporting someone to the medical board comes in and then wants to take a look at these types of arrangements. And obviously with the medical board's guidance on its website, it's very focused on these types of issues.
Yeah, just to make a comment, one of the challenges I think when we talk about this is, I feel like there are two different conversations among lawyers about corporate practice of medicine. And one, I saw my friend David Balfour is here somewhere. David, who's over culture, is that when I need to ask questions about what the real risk is on an enforcement level, I turn to people like David who are really devoted and focused on defending against the medical board. And that group of lawyers who's doing that work generally are not talking to the regulatory transactional lawyers. So you end up with like very conservative opinions in the regulatory transactional sphere, and then a lot of really practical intelligence. And one of the things that I hope comes out of programs like this and the follow-up is that we start like talking to each other across that divide, because I think that's where we miss a lot of the key information about where the risk is today on these issues.
Yeah, great point. I think also in terms of the practical risk, though, it's we'll see litigation between people who want to invalidate management agreements and other structures over corporate practice and medicine allegations. So you see private litigants going after it on using corporate practice as a sword to get out of arrangements. And then also payers may try to claw back money. In certain other states like New York, payers are very aggressive in coming in and saying, we're not going to pay. This is a sham medical practice using a friendly PC type structure and trying to claw back funds. They've been less successful, I think, in California doing that. There's some good case law on point, but payers, I think, are another entity or category of entities you need to worry about in this space. And then I've also seen it come up in transactions where you're doing diligence on a target and there's a corporate practice problem. And it's not that it gets reported to the medical board, but just practically speaking, you ask for a special indemnification that if it ever becomes an issue, you'll have some recourse. So that's another way it comes up and it sort of gets enforced or addressed. Okay, just some of the key corporate practice exceptions. We've talked about professional corporations and the friendly PC model. Obviously, professional corporations can employ physicians. HMOs, that's another exception. Public hospitals like LA County Department of Public Health employs thousands of doctors here in LA County. Licensed healthcare facilities like community clinics can employ physicians directly, certain drug treatment programs, and there are others. But these are some
question for you on that. I know, again, when I was sort of learning this doctrine, medical foundations, at least some folks might have it.
You're going to start a fight.
I know. That's, maybe it's intentional, but I noticed that 1206 L is not on there. Maybe we could talk a little bit about that and like why that there's a difference of opinion there. I'm happy to hand over the mic.
Yeah, I mean, I'm happy to start off. Originally, I did have it on here.
Yeah.
We decided to take it off because I think if it's an exception, it's a more limited exception. In that 1206L medical foundations cannot directly employ physicians, they contract with physicians. So in that sense, it's not a true exception. The reason why I think it's more of a limited exception is because those entities do bill and collect for professional services, can own medical records, and some of the other characteristics of a medical practice or an entity that can't employ physicians. So, but this is one where we had some fun back and forth with Gene.
Yeah.
preparing for this.
I think the struggle that I have with the qualify or calling it an exception is. I don't know where the authority lies that permits them to contract with health plans. I've looked and looked and looked and I don't see it. It seems that it has effectively just it's organically evolved that way without any enforcement oversight, and it's gotten to a point where it's almost taken for granted that it is an exception. But that's really where we struggle with it. And I think there's some really very good arguments to if you look at the statutes, to explain why actually from a statutory construction standpoint, that in fact, had they been intended to be an exception, there would have been language that's attached to other exceptions.
Yeah, well, I would say, I mean, I think it's always a better position to be in where there's an express exception.
Absolutely.
I agree. In the 12.6L, I mean, I see your point. I think you could argue it both ways, but as to actual authority for medical records for billing payers, I hear your point.
Yeah, and I was told, this is before I joined CMA, but CMA was very much involved in the 1206 legislation that led to the clinics, and I've spoken to the attorney that my predecessor, and he's like, yeah, we never intended that. But as things happen in this space, that's what in addition to the statutory authority and all the other things we look at, the industry standard has kind of moved in that direction. I think friendly PCs is maybe another example of that to some extent.
I think that's exactly where I was going to go on the next slide. And sort of wanted to use this as a moment to kind of pause, because it seems to me that at least in the past 10 years, friendly PCs have sort of grown in acceptance to the standpoint, or to the point where it almost seems like in most deals that I'm encountering these days, it seems to be the default structure for a lot of healthcare transactions and investments. And I'd love to get the thoughts of everybody on this panel to see if they agree, disagree, whether they're mad about it or they think that's this relatively gray area structure actually functions the way that it's intended. So maybe I can hand the mic to you, Harry.
Yeah, so I mean, my take on this, first of all, it is really staggering the extent to which the friendly PC model has just explosively grown over the last, I would say 20 years. And I mean, I think it's driven in part by the private equity world looking and the public markets, not to steal the thunder of one of my slides. We have like almost 60, by my count, 60 public companies that use this model now. And certainly it's driven in part by a search for investable assets and turning medicine into a place where investment capital can go. But also, I think it's driven by the fact that our healthcare system is so broken, and the experience of consumers and as patients has been so bad that the ability to bring non-physician, non-healthcare talent as founders and to improve the patient experience or to use technology, telehealth models, for example, is really also driving it. And so there's really no other good model for a way to integrate non-physician founders and investment capital with this physician ownership structure that's imposed on us. And the other alternative model, I'm curious, in a for-profit model that you could argue for is to say, well, we're a technology platform and a place where doctors and health professionals on one side meet patients, but that falls apart as soon as you start looking at how the experience is controlled and dominated by that platform. And so you see, like a lot of companies, I think MD Live and Dr. On Demand, you come up with a few examples of big organizations that started saying we're a platform, not using this model, and we're forced to shift over to this model. So to me, it's really this is really the big story of CPOM over the last 20 years, and the next big chapter is going to be, is there going to be a real challenge to this model?
Yeah. Well, I'll say I was at a conference last week where, and it was attorneys who represent medical associations across the country. And one of the topics was the corporatization of medicine, or private equity's influence in medicine. And we had some private equity guys, and I say guys because it seems like they're all guys. In their fleece vests and the way the private equity uniform. And this model was precisely what they had up on the board. It was much more complex than this, but it's become that ubiquitous that the private equity folks are walking into the room with this, saying, this is how you stand it up.
Yep.
And from CMA's perspective, well, I don't want to speak for CMA. From my perspective, I think the critical piece here is it's not that the friendly PC model is a good or a bad model. It's how you stand it up and how you put the governance in place to make sure and to ensure that the physicians have the right control over the broader organization.
Agreed. I mean, I think, I feel like it just can't be a one size fits all model. I think the devil's in the detail. And I think in some of the more recent litigation, they're getting into the weeds on, well, what could that management company do or not do? You know, what were the terms of the assignable option agreement? And so I think what's important is that these documents and the structure can't just be slapped together. I think they need to be, customized. There needs to be nuance with a lot of attention to detail, related to the laws we're talking about.
And I just want to make sure that everybody, for people who don't understand why this is challenging, we have on the left side, we have the state law driven rule that the physician has to own, a physician has to have a physician owned organization. But what effectively happens is through this management services and licensing agreement is that all of the revenue, or all of the profits, I should say, or not all the profits, but almost all the profits go over to the right side of the equation. And by virtue of this assignable option, the physician can be essentially ejected from the entity. So really the challenge, just to put, is do we still have, is this really a true model of physician ownership? And I think there's somebody who advocates for this and thinks we should have this, but this is where it's sort of, I just want to make sure people who aren't as familiar with it understand what we're talking about.
Is that it for?
Yeah, no.
Well, no, Rick, thank you for the great overview of some of the fundamentals. And this isn't, it doesn't cover every contour of the law. And certainly, this is mainly California focused, and, New York law is going to be different than California, which is going to be different than, Florida. So, this is meant to be high level. But now that we sort of have an overview, love to turn it maybe to you, Harry, just so that we have sort of a better sense of some of the updates, recent challenges, and proposals on the CPOM doctrine moving forward.
Sure. Did you want to advance, please? So, so first of all, we've been seeing California. This is definitely California. It seems that California and New York are the two states where we're seeing the most active challenges to CPOM, right? There are a few other activist states, North Carolina, Illinois, and so on, but those are really the two. And so in this case, this is actually the last Attorney General, by the way, 23 years ago. But when you read these Attorney General opinions, they're very conservative, right? And by the way, this issue, the question in this case was a management company's ability. It's described as to select a radiology site to which union member would be sent for care. Was the management company selecting where the member would go, and also selecting radiologists to interpret the study? Was that permissible? And of course, the whole thing was that in this opinion was that it was not. But this is a very live issue. That case that Rick mentioned, Allstate versus Discovery Radiology, is a fascinating case. It's actually being multiplied all over California. If you're working in imaging, we probably know about this case, but because it's being literally, Allstate has a model now where they're filing state false claims act cases against all these imaging centers, and they're saying, among other things, you are violating the corporate practice of medicine because you choose the radiologist, right? So that the imaging center, which is lay owned, is choosing the doctor that's going to interpret the image, and that in this case basically says, yep, that's a corporate practice of medicine problem. And so now Allstate is suing every imaging center in the state, more or less, that's involved heavily in personal injury, in personal injury work. So anyway, so that's the last AG opinion that we have. And I just, one of the cases that's fascinating is and this comes up more on the transactional regulatory side of this equation, rather than the enforcement side, is this Aspen Dental case. So it's an important case to know about. It's an important case from was settled in 2015, and this was the most aggressive enforcement action that the state of New York ever took against corporate practice of medicine. And basically, they complained. They began to investigate Aspen for essentially the friendly PC model that we saw on the page, but just saying the physicians are employed, I'm sorry, the dentists are employed by the management side. The management side is really guiding this company, and really the dentists don't have much control. They just staff the clinic. And what's fascinating about this case is, this is the case that scares everybody. It's like when California pursues something similar, because California generally, what's striking about the enforcement in this area is that the medical board, or the dental board, and the other Department of Consumer Affairs boards only really actively have jurisdiction over the licensees and not over the management companies. So we don't have a parallel to this case in California. But what's fascinating to me about this case is Aspen, New York made very broad allegations that we're talking about vision that are being made in other contexts in California. The management side, the MSO, was overreaching by all series of practices, including being the employer of record and really the control entity. And they achieved a settlement that they publicized heavily. And it sort of has reverberations. Literally, you can be anywhere in the country doing a corporate practice of medicine deal, and people will talk about Aspen Dental as the sort of boogeyman of, what's the risk of that? And then just a final coda that I put on the right side of the slide is, if you talk to the leadership of Aspen Dental these days, they are doing quite well, right? They've managed to adapt. And I think this is a big part of the corporate practice story, which is that the corporate world, the MSO side of the equation, always seem to figure out a structure and way to adapt. So today, Aspen Dental, in spite of this victory that New York claims over it, has almost $1 billion in revenue, 7,500 employees, 1,000 dental offices, serving 30,000 clients a day, and 30,000 employees a day. It's hard to imagine how much the dentist actually has autonomy, clinical autonomy in that model. So it's really it's a fascinating case. It's one you should definitely be. It's worth getting to know, to sort of think about what the risk is for active policing of management companies. Oh, you want to talk about this?
Oh,
yeah.
Probably you.
I imagine Jamie, you could have something. So this was a fascinating. So 2021 was a big moment for healthcare lawyers who are devoted to CPOM, because it was the first time in a major legislative effort to revise it and significantly impose control. And it was an interesting, fascinating bill because it combined provisions for more strict attorney general oversight over hospitals, which is a totally different, unrelated issue that in my opinion, seems to be a concern of the nurses union above and the Department of Justice. It's a long-standing concern. This issue of health facility oversight over clinical decision-making, but I think it's a big CMA priority. But what was fascinating was this third prong. It said that a physician, professional corporation shareholder and director was required to manage and ultimately have control over the assets and business operations of a medical corporation and could not be replaceable. That would be that assignable option vis-a-vis, I mentioned the stock transfer restriction, which is just another form of how you pull the physician out. And so, the key take on this case is it was a convergence of a lot of people who have concerns about private equity in healthcare. And I'm interested to hear your perspective, being closer to CMA. And it is ultimately one way this bill has not moved forward, but it definitely, I can tell you, it sent a quiver of fear through every private equity group that we talk to deal with this model. And it's not a major topic for today, but this Office of Healthcare Affordability that Jamie mentioned is very much, it's a much softer, but another piece of looking at this. And I'm curious to hear you talk about that.
In fact, that was, we can go into it now or later, but I was going to bring up OCA, in light of this. And
so I can touch on it now. I think what's going to be interesting is going to come out. Well, I'll say, as far as this bill is concerned, one of the challenges that CMA has in this space is that largely a large portion of our membership now is in the group model. They're not independent physicians, and the group model utilizes the friendly PC in many instances. And so again, it kind of goes back to that very nuanced position that CMA has taken, is that it's not the friendly PC that's the problem, it's the actual structure underlying it that can be the problem. But as far as OCA is concerned, I'm very concerned, I guess would be the right word to say. The Office of Healthcare Affordability is drafting regulations. They have emergency rulemaking authority right now. And that rulemaking authority has led to some proposed regulations that are attempts to scoop MSOs in.
Yeah.
They're trying to get enforcement over MSOs. I think the only reason that they haven't specific or expressly identified the corporate practice of medicine as within their scope is that they haven't quite yet figured out what it is. But they will, and they are granting themselves very broad authority on the regulations, and we're doing our very best, along with others, to try to persuade them that they need to stay within the confines of the statutory authority that they've been granted. So it'll be there's more to come on the OCA regulations, I'm sure.
Any comment on 642, or do you?
Well, I was involved at CMA in that legislative session. So the fact that it's been put on the 2-year list, it's kind of now, it is what it is. We'll see what comes out of appropriations, but frankly, because I wasn't there when we were lobbying on it, I really have not much more to say on it. Other than the fact that it's, like I said, we've evolved a bit where the CMA's membership base is shifting. And we need to be very thoughtful about that and understand that we're not just talking about the solo and small group practitioners anymore. We're talking about the larger group membership as well, and how do these things impact them and their business models.
And by the way, just a note, if you're not, this issue of assets and business operations being under the control of the PC, that's exactly how the MSO model is built, because the reason the MSO gets paid the profits, so much of the profits, is because it controls the intellectual property, the brand, and so on, and it controls the non-clinical business operations. So this would have been a radical remaking had it come to fruition.
Yeah, and I think that, the use of the term shall manage was pretty targeted. I felt like this reference in here was kind of slipped into legislation that didn't otherwise deal with this. And then the other thought I had, or a couple other thoughts. Yeah, we had a number of clients that were very focused on this. We were midstream in transactions and had a lot of, stressed out conversations with them about what would we do if this gets adopted? What are the workarounds to the friendly PC model, which is it's a workaround, where to go from here. And then one takeaway I took was also, I was thinking, I'm probably not going to use anything that I actually call a stock transfer restriction agreement anymore. I mean, there are other terms for that, but I wasn't going to use the term that was actually.
What do you use these?
I mean, succession agreement or assignable option agreement,
Continuity planning agreements,
all those types of
soccer.
Yeah,
Anything that suggests restriction.
right. And the last thought I had on this legislation was, look, if they had to expressly put it in there to prohibit it, does that mean that absent this being adopted, it's permissible right now? Is there that the other way of looking at it? So.
Okay, I'm gonna move forward just a tad to talk about Envision. And maybe I can tee it off. You could probably talk a little bit more about the details, but I just want to preface. I've had a number of clients who, they're worried about the OCA regulations and whatnot, but then as a sort of corollary to that, they'll ask about, what are you hearing about Envision? And I just want to sort of get a sense, and definitely want to start with you, Harry, just to talk about the case, but are you also hearing, similar sort of concerns about the outcome of the Envision case and, sort of the viability of the friendly PC model in light of what we have just talked about?
Yeah, so Envision is an very important case to be following. Envision is a friendly PC model, right? Envision is the publicly traded MSO. It is publicly traded, is it? I think it's publicly traded. Yeah, but it was anyway, MSO with a series of friendly PCs. And what's fascinating is a competing physician group, this American Academy of Emergency Medicine's physician group, sued. And they sued in the Northern District of California before Justice Stephen Breyer's brother. The case is set for trial next year. And essentially they argued that the friendly PC structure and the control that the MSO had, particularly over hiring, physician compensation, employment terms, that it gave structural control. But what's fascinating about this case is that the argument that the medical group AAEM made is that the medical board is not able to police the friendly PC model, so that they needed to file a case in federal court. And so this is going to be it's a potentially, if Judge Breyer really gets substantially into it, it's a fascinating case. And by the way, it's just not, I'm obviously rooting for the MSO side of this case, but I want to say that what's fascinating is when you read back through the medical board hearing, public hearings, in about 2009, the medical board actually said publicly at hearings, we are not going to police MSOs because they're multi-state, they have lots of money, and we can't effectively govern them. So this case, in this case, our argument that the medical board really is not able to police PCMSO, the model is actually in some ways openly true, because the medical board is essentially generally sort of stay away from the MSO side of the equation. So it's a very important potential case.
I don't know if Rick, Jamie, if you have any. Jamie, you might be more limited on what you can talk about.
Yeah, I mean, I'll just say that, we filed the case is clearly important to us as well. I mean, it's very rare that we will come in and file an amicus brief at the pleadings level, and that's what we did. We filed a brief.
And I intentionally switched the slide. And this is Harry's slide out here, but
Yeah, so we filed at the 12B6 stage, which is generally unusual. We typically don't get involved in amicus matter as an amicus party until we get into the appellate stage, where obviously law is being made. But we wanted to make sure that this case at least got forward to the trial stage so that the evidence could come out and the case could actually get heard. So that's about the extent of what I'll say at this point.
By the way, just to add a couple, this case was on hiatus it was originally set for trial in January, but it was actually on Chapter 11 by bankruptcy filing by Envision back in August. It just ended 2 days ago. So it's literally just came back from the bankruptcy stay. But some of the things that are really interesting in this case are, Rick talked about the Epic Medical Management Paquette case. That's a good case for kind of the legitimacy of MSOs, but it does not at all touch the friendly PC model. And one of the questions, when you talk about, Rick also talked about Business Professions Code section 650B, which says percentage of revenue are okay for the commensurate value of services. But when you look at these entities, the question is 99.99% of the net profit, in a large, and we'll talk about how big some of these models are, is that commensurate value, right? And so there's a lot of very important cases here. And then finally, there's this Prohibition doesn't get talked about a lot because there's an optician, case, but that was one of the most negative cases about corporate practice in a non-medical setting. And so this decision has the potential to really be a game changer.
Well, now that I think we have a pretty good, update on just the lay of the land as CPOM goes in California, I figured now would be a decent time to sort of open it up a little bit to Q&A. And I'd love to start with this group, and totally respect that people might be a little bit more limited in terms of what they can say, but to the extent that you can maybe offer a prediction to the Envision case, or at least your prediction for the CPOM landscape moving forward as you see it, or if not, if you had a magic wand and you could sort of dictate policy a little bit, what you would advise on that. So happy to maybe start with you, Rick.
Yeah, I think the one I'll respond to is maybe sort of going forward, what will this case mean either way? And I think when you look at the facts of Envision, the facts of that Allstate case that we mentioned, again, I think it comes down to, it may not be the model in and of itself that's a problem, especially if our friends at CMA are not anti in and of itself the model. I think it's how it's set up, how it's implemented, the physician's involvement. And so I think even if the Envision case, it strikes us down for purposes of that case, I think that the model itself still could be viable going forward if structured appropriately.
Yeah.
So, so my belief is that, the model is here, right? There's I don't know, close to, there's hundreds of billions of dollars of shareholder value represented. And I know I have a slide for the deck, by the way, just to, of some of the names, it's funny. It's not just obviously all the big telehealth companies like Teladoc that are, and Hims and Hers and so on, that are, using the model, but it's also like the United Healthcare. Optum is a friendly PC of United Health, right? So Anthem, all of its Elevance brands, that's all friendly PC, right? So friendly PCs are, and Amazon, of course, the $3 billion purchase of One Medical. So my feeling is that, corporate practice, friendly PC models are the horses out of the barn. Like I wouldn't bet against the shareholder value, right? And so what's fascinating is that we've had like 20 years of explosive growth in the space where state medical boards have really not kept up and policed it and have sort of been circumvented. And so it's going to be interesting how that gets reconciled. And so anyway, so that's what I would say is we don't even have MSO as a defined term, right? Except maybe in New York under the regulation.
We could have tried to define it.
They're failing miserably. They can't seem to really wrap their arms around it, but they're trying. Yeah, I mean, I don't want to, go down a policy rabbit hole here, but I think you're right. For 20 years, it's grown, it's out there, it exists. I think you mentioned earlier though, Harry, that this is a response to a broken system, right? And I'll put out there that, okay, so we've had 20 years of this. Is the system any better? Has this fixed the system? I don't know. I think the jury might still be out on that. Money doesn't solve the problem. This is a great way to get capital into the system and a great way to get profits out for non-physicians. But is it really helping the patient? I don't know if that's really happened yet. So.
Well, my next question was, and we can frame it, you guys can frame it how you want, was a little bit on best practices regarding friendly PC model or CPOM compliance generally. But I almost want to take a broader view of it in light of some of the comments that you've made, Jamie, just about, you're talking about the sort of, CMA is not necessarily opposed to a friendly PC, but it might take issue with the components of it or how it's actually built. In light of that, I mean, what would you say would be, certain things that could improve the model or could alleviate some of the concerns with sort of the cookie cutter friendly PC model that a lot of, PE funds are putting in place?
Well, yeah, I hate to keep going back to the same the same old line, but the critical piece of it is clinical control. Do the physicians have control? Do you have the governance structure in place that allows the physicians to exercise the control over the things that matter? Let's say in the hospital context, who's making the determinations on, if you're going to establish a bed day metric and you're going to have adverse consequences for physicians who perhaps exceed a certain metric? Who's setting the metric? Is it being set at a corporate level? Is it being set by the physicians? I would argue that is something the physician should be setting. So again, that's why I find Envision is going to be interesting, because if I could wave the magic wand that you gave me, the Envision would come out, there would be a decision there that became law that really added some clarity as to where the line's drawn. They're very broad right now. They're very general. There's really, and I think that some clarity in case law and perhaps through statute that would allow the friendly PC model to exist in a way that preserves physician independence would be a good thing.
I was going to say, in terms of things that really, a couple of things. Number one, I think the key, there's these two dimensions of corporate practice. Nobody argues about clinical decision making and the need for clinical leadership, right? And so I think the best practice to sort of make the model work is you operationalize clinically driven leadership and you recognize that there's a clinical dimension to almost every aspect of the way that these companies are structured. And the other thing I was going to say that there is a massive void. I said this to you months ago, but I really believe that we as healthcare leaders, in some ways, we sort of figured out how to structure these deals and get these deals done for the sake of private equity and getting deals done. But we now have a responsibility, since medical boards are not policing, to create accreditation standards and to really create a uniform approach that's shared by all the key stakeholders. Because we're ending up with this kind of split, schizophrenic approach to policy. By the way, it's fascinating. It's another slide, but the IRS has figured out a model to make this work. Right? It's fascinating. By the way, if you do these deals, you'll be asked about the IRS. It's trying to find it. Sorry, it's in there somewhere. So the IRS, the IRS in the last, it's not a mistake that the IRS has issued 2 private letter rulings that specifically allow for professional corporations to be consolidated on the tax returns of public companies. And they solve the problem from a tax perspective. But meanwhile, like medical boards are just have not, and it's not their fault, right? They only equipped to sort of, medical boards are used for policing the doctor prescribing, doctor practice, doctor, impairment. They're not used to prescribe to policing this stuff. So I think the stakeholders in the healthcare industry, but hopefully healthcare will be part of really articulating national standards so that we can eliminate some of the uncertainty that is pervading.
Rick, I'll turn it to you for the final word before I think we'll open it up to general Q&A.
Okay. Yeah, I've had a few engagements and they've been pretty fun where I've represented the friendly physician in these models, and it's been a good experience to see it through their eyes. And some of the advice I give to them is you have to be hands-on. They want you as the physician owner because that's important for the model, but you need to understand, who you're employing, what the locations are. You need to see some patients and think about if the medical board came in here and interviewed you about this model, how knowledgeable would you be about the day-to-day operations? And so that's something I've really tried to emphasize to physicians when I'm on the friendly physician side of the equation too.
Great. Well, thank you for laying the foundation and then also just giving updates to the doctrine and a couple opinions here and there. But I'd love to sort of open it up to the audience to the extent that folks have questions. Over there. Sir.
Thanks, Jordan. Super helpful, guys. Thank you. You can go back to slide 18. So I get that the purpose of the model is from a PE perspective is to sort of shift revenues from the clinical aspect of healthcare services to the administrative aspect. My understanding is like the MSA here is supposed to be fair market. And so I would think that that's a safeguard. And so I'd love to hear from you guys on, is that a safeguard, right? That the monies that are moving to the MSO are fair market? And what do you sort of advise clients that run MSOs in terms of how do you make sure, or sort of, do you always get an independent third party evaluation to get comfortable that the 99% of revenues is fair market, or what sort of comfort do you get? Do you sort of seek to get comfortable that the payment arrangement between the friendly PC and the MSO is fair market?
Hand the mic off to whoever wants to take a cut.
So I think it's critical to get valuation opinions. The challenge with that is when you operate this at scale, talk about there is a friendly position by the cardiologist up in Toronto who's not shown anywhere I don't represent something right. There's not much left in that friendly PC. California PC, so I think it's critical to get a friendly value opinions, commercial opinions, but what you end up with practically is a situation where the PC has to end up operating at essentially a revenue neutral position if the entity is going to pass on the net revenue to its investors, to its stakeholders. And so, so I think those opinions are important, but I think you end up with this bizarre situation. And what we usually end up saying to, the medical defense of the medical, that the friendly PC shareholder essentially was not a great business person because they ended up all the revenue flying out as intellectual property royalties and management fees that are supported, but they ended up with really nothing there other than whatever fixed compensation, whatever equity they may have in the management side, because that's the only side that has accretive value that you actually want to own from a value perspective, and some kind of fixed compensation for things that aren't the practice of medicine, i.e. that consulting agreement at the top of slide 18. So, that's sort of where we end up, but it's not I wish that doesn't, it's not a position that's easy to articulate where in the statutes or regulations we got that from, but that's as a practical matter how I would describe it.
But Harry, isn't the professional corporation paying the docs?
Right. So every physician who's contracted or employed by the PC can be paid as a W-2 or 1099 of the professional corporation. But the question is, what about that PC shareholder and director?
I understand, yeah.
Yeah, so that person, essentially for this whole model to work at scale for one medical, for example, that there can't be any profits left in the professional corporation, or else the shareholders are going to be squawking at Amazon, that they're not the revenues being withheld here, right? And if that person is a founder, maybe that person wants to, if that's Jeff Dean, let's go back and gets his MD, then it solves the problem.
Right.
But if not, whoever the shareholder is of One Medical is really, there's almost no way to give them a meaningful percentage and still meet the demands of the stakeholders in the MSO. Right.
Yeah, and I was gonna add, I think it's very important that it's within a range of fair market value, but like Harry said, I think it's a little bit more of an art. But I would also add, and it's not the topic of this presentation, but we care about that for other reasons as well, like the anti-kickback statute, if there's any marketing, if there's physician ownership in the management services agreement, we may have stark concerns depending on how that management fee is structured and what kind of services the professional corporation provides.
Thanks, guys. Has anyone seen a situation where a friendly physician became unfriendly and tried to detach, maybe go with another MSO, where they were trying, then the MSO tried to enforce the assignable option agreement, but somebody defense that by arguing corporate practice of medicine?
So friendly gone rogue.
Yeah, so I've seen situations where not drafted by any lawyers in California or Los Angeles, where there was a physician, the friendly physician went rogue and realized that there weren't good mechanisms in the agreements to unlock them. We saw a large company that came to us in crisis going to bankruptcy and ultimately disappear. And the friendly physician went off and basically pulled his PC into, and went off laughing into the distance. So we've had this come up in a number of cases. The way we're usually trying to address it is by ensuring that there's already documentation at the beginning of the transaction that empowers the unilateral transfer. So, for example, having an undated stop power from the shareholder so that the transaction can be effectuated and recorded and by the time the litigation starts weeks later. And I've had this situation also where we've been tested on that in a couple of cases where PC shareholders sued. It was already too far down the bridge. They weren't going to get injunctive relief because they had signed the stop power for the transfer, and the fact that it was undated when it was signed, that judges still, we've had good experiences with that model, but I think it's literally a catastrophic situation if you haven't created a remedy to protect, if you're on the MSO side of this equation, to ensure that the company has a way out, a way forward that doesn't depend on going to court and waiting weeks and weeks for a remedy from a judge.
Yeah, I agree. Going to court also brings the model front and center for the court to review at that point, which is not desirable. I haven't been involved in one of those types of cases. I've heard anecdotally about physicians going rogue, taking money out of the bank account and leaving. And I've heard anecdotally that the MSO at that point decided to just let them do it. Take the money, it was 30 or 50 grand or something like that, as opposed to fight this and take it to court.
It's, by the way, I think that the issue of the physician going rogue is very different if you have insurance contracts and Medicare, if the progressive corporations in locked into government programs and the revenues are flowing, that was the example, the bankruptcy example. If it's in a direct to consumer cash base, obviously, disconnect one PC or like Rick's looking to and have just form a new PC. So I think that's a huge part of the equation also. But we've had a number of cases where the decision has been just to settle with the disgruntled family shareholder and pay them off. And my experience is that's the majority of cases, a little bit of grease makes the wheel go.
I think one of the interesting things that we haven't talked about very much is the impact on the patient. And I think we will all age. And when you do, you will find out that your relationship with your doctor is something that you count on. So one of the things that has not been said is that is a sacrosanct thing that needs to be protected. Now, there are ways to protect it and still have large organizations involved. And so the problem with that is that there are different slices of what those organizations are. For example, 1206L medical foundations are predominantly being operated not by how the statute was originally intended to, which was for a community to set up a nonprofit that supported the organizations. If you go back and look at how Palo Alto Medical Foundation and Santa Barbara Sense Clinic was first, they were the subject of the 1206L statute, in case some of you don't know that. It had nothing to do with hospitals. One of our colleagues in the early 90s, who was working on his PhD at Harvard, used the corporate practice for his thesis. He's the one that came up with using 1206L. Some of you will remember this. And so the upshot of it is that that's one group of situations. But today we have tremendously large foundations. They employ thousands of doctors. They are typically affiliated tightly with health systems. And we have a great deal of care being done. We also have the university system, my university, I'm a property, UCLA, and they have their own exemption. And then you have the PE world, and then you have the smaller private world. Each one of those groups that are controlling medicine through the vehicles of management companies or other entities, they're a little bit different, and they have to be thought about different in order for things to work the way it does. My concern is, as a senior member of the community now, is how is the patient treated? When we read about things, and many of you have, about dermatologists given 9 minutes to treat patients and complaining that for older patients, they can't possibly see some woman and examine whatever it is that she needs within 9 minutes and being penalized for it or pressured for that, that's the kind of thing that makes people like me go nuclear. And so what I would say is, just wait, some of you that are young, you will get to this point, and you will have a real need to have a very solid connection with physicians, and you won't want people telling somebody what to do to cut you off. And more than that, you will be very unhappy when you're told by AI that, well, maybe you don't qualify for that, or maybe it's not necessary in your case. So what I'm saying to you all is, in this state, we do have robust laws. There's a reason for them. And for the most part, those reasons haven't changed. We need to protect patients. The patients need to have doctors that aren't put under the thumb of somebody else so that they do the right thing. And in fact, the friendly PC model can be made to do just that. Just like in hospitals, the hospitals have medical staffs, where the medical staff is part of the accreditation. We can do that with these other organizations. So this is obviously at a fairly high level. And what I'm saying to you all is, this isn't a stupid topic that you all came to today. This is an important topic. It's important because of the consolidation of medicine. It's important because of the need to use resources very carefully in healthcare. And we'll see increasing pressure as we become 1 out of 4 above the age of 65 by 2030. A stat many of you know. This is indeed a very serious topic.
Tony, thank you. Tony, I appreciate, I wanted to add to your comment, by the way, one of the things that's interesting, and we haven't, it's a, you're making an important point about the critical question of how the patient is affected by the setting, by the structure. One of the things that's really interesting to me is that the people who are the most concerned about private equity seem to glorify nonprofit models. And to your comment makes an important point, which is it doesn't matter ultimately whether you use it. You know, there's no. I don't believe there's a great virtue that we should assign to nonprofit versus for-profit. The real question is how is it working for the patients and for the providers?
Yeah, and I think I'd add on to that, you know, while the focus of this discussion on corporate practice really seemed to boil down to the friendly PC, there's other aspects of the corporate practice of medicine that impact physicians and patients beyond this particular model. You know, one of the largest areas where we run into it at CMA is through our organized medical staff, and the challenges that they face working as medical staff in hospitals, and the overreach, if I may say, that hospitals engage in, both not just in how they perform their professional duties within the hospital, but utilize the peer review system as a tool to pressure physicians into line, and get them into line and to do the things that they need to do. I think another interesting area where the corporate practice of medicine is becoming more and more apparent is in the movement, in the labor movement in this country. A lot of physicians are talking about unionizing. Well, you can't unionize in California's physician very easily, if at all, if you can't employ, if you're an employee. So there are physicians who are unionized and they're employees, but there are many others who talk about it, and many in our membership who do. And we remind them, well, you know, you're gonna, if you gain, you're gonna have to give up. Right? If you want to unionize, you're gonna have to give up some of that independence, because that doesn't, it runs headlong into the corporate bar and the corporate practice of medicine. And I think lastly, I think an interesting place where the corporate practice of medicine is also coming to play in California and in Texas, where there's some similarities, is there's a public service loan forgiveness program that's offered by the federal government. And we're going to cover that? No, go. So yeah, so we at CMA, so for years, physicians are entitled to avail themselves of this program, as are many others. But in California and Texas, physicians weren't able to do it because you had to be an employee of the not-for-profit or the public service entity that you for which you were saying, well, I deserve credit for that time to forgive my loans. And we at CMA work very closely with the Texas Medical Association to get the Department of Education to modify the rules to allow physicians in California, very recently at this point in effect, to allow them to avail themselves of that public loans, the federal public loan forgiveness program. The interesting thing, though, that this is all, it's like a balloon. You squeeze one part and the air goes somewhere else. Yeah. Then I get calls from leaders of for-profit medical groups who are telling me, well, wait a second, we love that we think it's, from a policy standpoint, this is great, but guess what? The not-for-profits are now using it to recruit physicians away from us. So I'm like, well, you know, it's one of those, you know, no good deed goes unpunished, right?
Yeah, I'm getting a lot of questions on the PSLF program at this point. I think, you know, CMA did a great job getting that in there. And I just think it's interesting that the Department of Education essentially, you know, acknowledged the corporate practice prohibition and some of the other structures that we've been discussing, and now allowing those physicians to potentially qualify for the loan forgiveness.
Took a lot of educating.
Yeah.
Rick, I mean, didn't you get actually some feedback, I think, from like someone at Department of Education on that?
I have, yeah, I've emailed the persons listed in the regulations, and they've been very responsive in terms of acknowledging our interpretations of the regulations, and agreeing that physicians who, you know, prior to that wouldn't have qualified now do qualify. And what I think is CMA has an excellent publication on that program as well, with some good FAQs. I think it's interesting because a lot of it does speak to the corporate practice prohibition. And so, for example, county hospital can employ physicians. So if a physician works for a for-profit medical group that makes its physicians available to a county hospital, you know, they wouldn't qualify because they could have been directly employed by that county hospital. So you have to really sort of think through, I don't know if that was clear enough, but the corporate practice implications in terms of who can employ the physicians, who can't, and then, you know, what circumstances will they qualify for this? Yeah.
I got a question about the structure up there. So we go to great lengths to try to structure the BC friendly shareholder arrangement. Everything's great. But then there's a lender, a third party lender on the outside that has powers. In the olden days, I guess I'm like Dr. Tony, I've been doing this more than longer than I should be. I liked his point too. In the olden days, you used to give a security interest in the revenue streams, but what I've seen now in a lot of deals is, you know, the lender actually has a right to come in and take over. And I was wondering what you guys thought about that. I mean, you have some great comments here about, you know, the friendly shareholder, you got the group there, but what about giving those rights to the outside lender and, you know, getting the actual pledge on that? Is that what you guys see now? And does that give you guys heartburn compared to just saying, you know, you get a right in the old revenue proceeds, which, you know, may have done, you know, 15 years ago or more? But I'd be interested in the panel's thoughts on that.
Yeah, we're definitely seeing what you're describing, creditors taking more aggressive stance and wanting the power to come in and take control. And I think, by the way, I think that of all the places we talked a couple of questions ago about the management fee and the way that the revenues flow to the MSO, but the bigger question is who gets to decide who the next, you know, physician shareholder of the professional corporation is. That's almost like the most important clinical choice of all, right? This is going to be the supreme decision maker, and so I think the lenders pushing in, which we're seeing more and more, it comes back to that question, and it's really, I think, in some ways the most profound and troubling, you know, question to support, you know, this model.
Yeah.
I just have a real quick question, but I probably don't need the microphone. You know, in light of the risks that we've been talking about here, we have all this public money going in, like that one slide there where we have all these well-known insurance companies, United, Aetna, whatever, who are taking positions in these spaces. What kind of disclosures do they make in their securities filings? Okay.
By the way, I will tell you every few months, just this is like my own little personal craziness, how geeked I am with this issue. I'll go to the 10B SEC database and I just start doing word searches and for corporate medicine friendly professional corporation. And that's how I'm able to figure out which ones are using the model, right? Because not most of them I haven't are not famous brands, right? These are only the most well-known kind of names. But so it's clear from when you read their disclosures, they're all disclosing corporate practice of medicine compliance as a risk because they're using this model. But what's fascinating to me is like, we're not talking about small names, right? It's not, I used to think it was just Teladoc, right? Since they were the grandfather of all, grandparent of all, you know, telemedicine companies, but it's these massive players and CVS, by the way, Aetna also, right? What's happening in CVS MinuteClinic and Walmart and all these, you know, this is like, so everybody's sharing this in their documents. And it's fascinating to me that it's, in some ways, it's almost the shakiest compliance issue, right? We have 50 years of the OIG telling us exactly what the anti-kickback statute means and how it's evolved in case after case. The relative paucity and the absence of defining authority on this is, in some ways, it's fascinating.
Yeah, I think when you started seeing the friendly PC model in 10Ks, I felt like it took it to the next level, because until that point, kind of felt like the friendly PC model was a little bit like the first rule of Fight Club, you know, where you didn't talk about it. You started seeing it on the SEC website in these filings, you thought like, hey, there's a huge public company that's told the world that this is the model.
Yeah.
Anyone else?
Specifically in the telehealth space, when can you distinguish using the MSOPC model versus just a platform model and have independent contractors as providers? Like, what would be the pros and cons versus that making either of those choices?
I mean, I made a comment earlier, you know, I think that the problem with the platform model works perfectly if all the software is a, a meeting place that makes a market between qualified health professionals on one side and patients in need, and the patients and providers can be essentially verified and matched up. But that's none of the models that we're looking at in telehealth actually like resemble, or I think that model is out there, but the brands that we know are known because they develop user experience and a customer, expectation of what you're going to experience. So once all the choices that create that brand and that user experience are defining and structuring what modalities of care are going to be rendered and what medications are going to be available, what's going to be treated. Once you start setting those rules, you're making those are clinical choices. So I think that these platforms really doesn't hold up in like highly structured branded model.
Yeah, it might be safer in certain states and other states too, if you're using the independent contractors to engage. So it may be state specific to some extent, although with the telehealth model, it tends to be all 50 states, so you have to be careful.
Well, I lost my mic, but. Any other folks with questions for the panel? Okay, well, I mean, with that, unless any of you folks want to tell some interesting war stories, I think this was a really educational panel, and really appreciate everyone's participation here.
Thank you. Yeah. I want to thank you for organizing, and there's a lot of work that went into this. This is supposed to happen last spring, so I'm really delighted that some people came out for this. And I just want to say, I think this is really, Tony made a very important point about the importance of this for patients, but I think this is one of those areas where we as healthcare leaders have a unique responsibility and unique opportunity to really impact something that's less certain and established and clear than many of the other subjects that we deal with.
Yeah, I agree. And I thank you, Tony, for making that point. I think as attorneys working in this space, I think it's important for us to remember, not just our ethical obligations to our clients, but the fact that we're doing something that we work in a space that is going to touch everybody's life. It touches everybody's life. There's not a person who does not have to interact with the healthcare system. And I think keep that in mind, and let's do what we can to make it better.
Final
I guess I want to thank Nelson Hardiman for hosting a beautiful space here. And I just think there's going to be a lot of exciting developments here in the corporate practice space over the next few years with these cases and developments, potential legislation and SB 184. So I think there's going to be a lot of fun for us to monitor this. And thanks for coming tonight.
Thank you.